Here's what you need to know about Turkey Halk Bankasi versus United States, case number 20-1450, which was argued before the Supreme Court of the United States on January 17, 2023, and decided on April 19, 2023. In this case, the court was asked to decide whether 1. A district court has subject matter jurisdiction over a criminal prosecution under 18 U.S.C. Section 3231, which is the General Federal Criminal Jurisdiction Statute, and 2. If the Foreign Sovereign Immunities Act of 1976 provides immunity from criminal prosecution. The court held that the district court has jurisdiction under Section 3231 over the criminal prosecution of a Turkish bank, and that the FSIA does not provide immunity from criminal prosecution in U.S. courts. Here's how the case ended up before the Supreme Court. The United States indicted Turkey Halk Bankasi, also known as Halk Bank, which is owned by the Republic of Turkey, for conspiring to evade U.S. economic sanctions against Iran. Halk Bank filed a motion to dismiss the indictment on the ground that it is an instrumentality of a foreign state and therefore immune from criminal prosecution under the Foreign Sovereign Immunities Act. The district court denied Halk Bank's motion. Halk Bank then filed an interlocutory appeal with the Second Circuit, which affirmed the decision, after first determining that the district court had subject matter jurisdiction over Halk Bank's criminal prosecution under Section 3231. As to the FSIA, the Court of Appeals assumed without deciding that the Act confers immunity in criminal proceedings to foreign states and their instrumentalities. That said, the Second Circuit held that even if the Act conferred immunity in criminal proceedings, Halk Bank's charged conduct fell within the Act's exception for commercial activities. Undeterred, Halk Bank appealed to the Supreme Court, and the court agreed to hear arguments on the questions whether the district court has jurisdiction under Section 3231 and if the FSIA provides immunity in criminal cases. Before the Supreme Court, Halk Bank argued that the indictment should be dismissed because Section 3231 does not extend to prosecutions of instrumentalities of foreign states, such as Halk Bank. In support of that argument, Halk Bank identified certain civil and bankruptcy statutes that expressly refer to actions against foreign states and their instrumentalities. Because Section 3231 refers generically to all federal criminal offenses without specifically mentioning foreign states or their instrumentalities, Halk Bank reasoned that foreign states and their instrumentalities do not fall within Section 3231's scope. Halk Bank also pointed to Section 3231's predecessor, a provision of the Judiciary Act of 1789, which did not specifically reference foreign states and their instrumentalities. In Halk Bank's view, other statutory provisions from that same era, including several that referred to suits against foreign actors, suggest that Congress would have expressly referenced foreign states and their instrumentalities if Congress had intended the 1789 provision to reach those entities. Halk Bank maintained that the court should read Section 3231 like its predecessor provision. Pressing further, Halk Bank invoked a separate provision of the 1789 Judiciary Act, granting district courts jurisdiction over all civil causes of admiralty and maritime jurisdiction. Halk Bank asserted that the court has construed that provision not to confer jurisdiction over foreign state entities, and that the court should, therefore, construe Section 3231 in the same way. In addition to these jurisdictional arguments, Halk Bank argued that the FSIA provides instrumentalities of foreign states with absolute immunity from criminal prosecution in U.S. courts. Here's how the court resolved the dispute. First, the court disagreed with Halk Bank's argument that because Section 3231 does not specifically mention foreign states or their instrumentalities, the statute implicitly excludes them. We decline to graft a textual limitation onto Section 3231's broad jurisdictional grant over all offenses, simply because several unrelated provisions in the U.S. Code happen to expressly reference foreign states and instrumentalities, the court reasoned. In the court's view, those scattered references in distinct contexts do not shrink the textual scope of Section 3231, which operates without regard to the identity or status of the defendant. Second, As to the predecessor provision in the Judiciary Act of 1789, the court found Halkbank's argument unavailing because the 1789 provision, like Section 3231 itself, contains no exception for prosecutions of foreign states or their instrumentalities, and the court had never suggested that the 1789 provision contains an implicit exception. Third, and relatedly, the court rejected Halkbank's secondary argument involving the 1789 Judiciary Act because it was premised on a case that addressed common law sovereign immunity, not statutory subject matter jurisdiction. Fourth, after analyzing the history, text, and context of the FSIA, the court concluded that it does not provide foreign states and their instrumentalities with immunity from criminal proceedings. The court began its analysis by explaining that the doctrine of foreign sovereign immunity originally developed in U.S. courts as a matter of common law rather than statute. Then, in 1976, Congress enacted the FSIA, which prescribed a set of legal standards that governed claims of immunity in any civil action against a foreign state. Notably, Congress described the act as defining the circumstances in which foreign states are immune from suit, not from criminal investigation or prosecution. Furthermore, the court explained that while it had repeatedly stated that the statute applies in civil actions, it had never applied the Act's immunity provisions in a criminal case. Against this backdrop, the court turned to the statute's text. It noted that the first provision of the Act grants district courts original jurisdiction over any non-jury civil action against a foreign state, as to any claim for relief in personam with respect to which the foreign state is not entitled to immunity. Further, the court observed that the Act sets forth a carefully calibrated scheme that relates only to civil cases, and in stark contrast to the many provisions concerning civil action, the Act is silent as to criminal matters. Turning next to the statutory context of the Act, the court noted that at the time of the FSIA's enactment in 1976, the executive branch occasionally attempted to subject foreign government-owned entities to federal criminal investigation. In light of this history, the court thought it unlikely that Congress sought to codify foreign sovereign immunity from criminal proceedings without saying a word about such proceedings. According to the court, the Act's location within Title 28, which mostly concerns civil procedure, further bolsters this inference. The court also rejected Halkbank's claim of immunity from criminal prosecution based on one sentence in the Act, which provides that a foreign state shall be immune from the jurisdiction of the courts of the United States and of the states, except as provided in sections 1605 to 1607 of this chapter. The court determined that, read in context, this lone sentence operates exclusively in civil cases. Finally, the court determined that Halkbank's remaining arguments lacked merit. First, the court concluded that Halkbank's reliance on Argentine Republic versus Amarada Hess Shipping Corporation, a civil case from 1989, had no bearing on whether the Act provides immunity in a criminal context. Second, contrary to Halkbank's assertions, the court concluded that the federal rules of criminal procedure would provide courts and the executive branch with sufficient guidance in any federal criminal proceeding. Third, the court rejected Halkbank's argument that criminal proceedings against instrumentalities of foreign states would negatively affect national security and foreign policy. The court reasoned that it was duty-bound to interpret the Act as it was written, and that if the current principles do not protect national security and foreign policy, it would be up to Congress and the President to respond. Based on this reasoning, the court affirmed the holding of the Court of Appeals that the district court has jurisdiction under 18 U.S.C. Section 3231. With respect to the Second Circuit's holding that the FSIA does not provide immunity to Halkbank, the court affirmed on different grounds, namely, that the FSIA does not apply to criminal proceedings. The Second Circuit did not fully consider the various arguments regarding common law immunity that the parties pressed before the Supreme Court. So the court vacated the judgment of the Court of Appeals and remanded for the Court of Appeals to consider the parties' common law arguments. Justice Kavanaugh delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Sotomayor, Kagan, Barrett, and Jackson joined. Justice Gorsuch filed an opinion concurring in part and dissenting in part, in which Justice Alito joined. Justice Gorsuch wrote separately to explain that he would have adopted the Second Circuit's analysis and holding.